Okay, let's get going with our directors panel. So we started this conference in 2014. We had one panel. It was a directors panel made up of all of the current and former West Coast regional directors that we could find. And the personalities and the insights and the historical perspectives that came out of that panel made it really popular to the point that that one panel turned into a day of panels into what we're doing right now. So pleased to introduce our moderator, who's been our moderator all along in this panel, Jordan F., the partner and co-chair of Morrison Foerster's Global Securities Litigation Enforcement and White Collar Defense Group. Jordan is truly one of the leading securities litigators in the U.S. He's a fixture in the Bay Area, more than 3 decades of experience representing public companies and their officers and directors and just about every type of matter you can imagine. Welcome, Jordan.
Thank you.
Jina Choi has been a key part of this conference since we started it in 2014 as well. She was originally here, of course, in her capacity as director of the SEC's San Francisco regional office, where she was on the staff for over 16 years. Today, she's a partner at Morrison Foerster in San Francisco, where she represents public and pre-IPO companies, financial institutions, and much more. Welcome, Jina.
Thanks, Bruce.
Very pleased to introduce Michele Layne, who has been with us every year as well since 2014, and she's the regional director for the SEC's LA office. She always has to make the trip, unfortunately. But she served at the SEC since 2005 and has led the LA office since 2012. Under her leadership, the LA office has produced some of the most significant cases brought by the SEC, and it's always a highlight for me to work with Michele on this conference. Welcome, Michele. Thank you.
Thank you.
Randall Lee is a partner at Cooley with over 30 years of experience in both government and the private sector. Randall is the former regional director for the Pacific region of the SEC, where he was the top official in 9 Western states, including California. Also the first Asian American ever to head an SEC regional office, and previously served as an AUSA at the U.S. Attorney's Office in LA, as well as deputy chief of the major fraud section. Welcome, Randall. Finally, very pleased to be joined by Monique Winkler, who in March of this year was named the acting regional director of the SEC's San Francisco office. Monique joined the San Francisco office in 2008 and served as a member of the Public Finance Abuse Unit from its formation in 2010 until August 2019. Congratulations, Monique, and thank you very much for joining us.
Thank you.
Jordan?
Thanks, Bruce, and good afternoon, everyone, and good afternoon, everyone at home. Monique, we're going to start with you, even though you're way down at the end. You can't hide. You can't hide. So you've been doing this now for 6 weeks. You've been at the SEC for, I don't know, what was it, like 14 years or so, but only 6 weeks on this job. So how's it going? What's surprising you? What's new and different in that role?
I think it's going pretty well. Hopefully nobody in the audience is going to raise their hand, including my boss, and say it's not. And I do think I have my predecessor, Erin, to thank for that. She's not here, so I don't have to be nice to her, but she did a great job of, I think, being a role model, being a great leader, and preparing me for this job in the short time that we had before she left. So I think, I feel like things are going well. There's been a few surprises. I shouldn't really have categorized them as surprises, but I'd say one of them is just the support I've gotten all the way down, from the staff all the way up to the
You haven't gotten any support, is that what you're saying?
No, I've actually gotten a lot of support.
Oh.
And I mean, some of the people that are supporting me are in this room today, and they're supporting me by just continuing to do a fantastic job, despite sort of the turmoil that's, I think you could call it turmoil, that's happened in the San Francisco office recently. And support from my fellow regional directors. Michele has been great. She's actually volunteered to answer all the questions for me today.
We won't let her do that. But.
No. And probably the second thing that I didn't think was possible was to actually have more meetings on my calendar. I thought there was actually no room, and now there's literally no room now. Meetings every day. Meetings every hour of every day. But challenges, besides being here right now, I think not only it's the challenges of taking on the acting director role, but continuing to do my old job, and then I think most importantly, sort of losing my backup for my old job, my sounding board, my boss. So it feels a little isolating, but with the support out there, it's been good.
So Jina, that used to be your old job, right?
That's right.
So I bet you have some tips, especially now that you've been on the other side, some tips that you could pass along to Monique.
Well, Monique doesn't need any advice from me. As a lot of you in the audience know, Monique has great experience. She came up in the office. She's worked on great and impactful cases. She's worked in a unit. She's worked in the core with the core staff. She has great relationships inside and outside the office, and she's really in a terrific position to lead the really outstanding staff who I see today in the audience in the San Francisco regional office. Monique was kind enough to say that she was looking forward to my advice, so I will give her 2 pieces of advice. And one is specific to the San Francisco regional office. This was advice that was given to me by one of your former partners, Jordan, David Bayless, who was the head of the San Francisco office a while ago. And he said to me, there's good news and there's bad news. The good news is you're 3,000 miles away from Washington, D.C. And the bad news is you're 3,000 miles away from Washington, D.C. And the other piece of advice I give to virtually everybody that I care about, I give this advice to my kids, I give it to my clients, and that's it, that of course you have to learn from your mistakes, but it is much less painful and much less traumatic to learn from other people's mistakes.
Excellent.
Thank you, Jina. I appreciate that.
Yes. All right, so Michele, we're going to turn to the important substantive topic of the work environment. We've all been talking about it for a couple of years. And I'm curious, are people in the office all the time? What about testimony? Is that in the office, out of the office? And then how about recruiting people? You know, there's been an issue apparently of, difficulty recruiting people, a hot labor market. How are you getting people to join the SCC? Are you offering, free lunch and foosball, or what are you doing?
Yes, of course. Okay, so I'll take the last question first. So attracting great candidates is not a problem because the perk we have, and I don't mean to sound sanctimonious here, it's the work itself, right? I mean, the formers will all attest to it is one of the greatest jobs because it's a privilege to be on the right side, try to do the right thing. It's challenging. It's always changing in so many different ways that really is the biggest perk that we can offer to attorneys, accountants, folks who want to join the commission. And then as far as the work environment, obviously like every organization and institution, we have evolved since 2+ years ago. So I think overall, we're really effective at doing our jobs from home or other locations. But of course, there's certain things that are best being done in person if possible. And so really, since the pandemic began, and then certainly since people have been able to be vaccinated and the virus is not quite as dire as it was in the early days, there's a variety of activities that take place in the office, meetings, testimony, and then also even, throughout the pandemic, we've had in-person trials, hybrid trials.
Are you requiring people to come in 5 days a week?
No.
Okay. What are you doing?
We now are in a voluntary status, which means you can come in voluntarily.
Okay. So Randall, have you sensed any changes in light of the hybrid environment that we're in terms of dealing with the SEC?
I would say not yet. And it's actually, I think, a question that I have for Michele and Monique, which is, what is your position on in-person testimony and in-person meetings? The strong message I've gotten in my interactions with the staff is that in-person meetings and testimony are discouraged and actually not welcome. And, there are times where I think from my perspective, I would prefer to be in person, whether it's meeting with one of you or whether it's bringing a client in for testimony. And it's, I think, for those of us on the defense side, not been entirely clear whether that is something we can push, whether that is something we push at our own risk, or whether that is something, that is just not being done. So
Well,
that was a
Michele?
question.
Oh, a question? Okay.
That wasn't rhetorical.
No, but he said Michele and Monique, so I'll go first.
Yeah.
So what I would say, at least, again, like based on my experience in our office, we have testimony depositions that are occurring in the office. We have meetings with outside parties in the office as appropriate. And like so many things, it's case by case. There's no directive or protocol to avoid coming into the office if at all possible, and there's no mandate to come in if at all possible. I think it really just depends on the circumstance. And so, but what I just can provide, again, based on my own experience, is I think testimony is different, for instance, in comparison to a Wells meeting. So I understand the issues with obviously wanting to be in the room with your client, wanting the exhibits in paper on your table with the client sitting there. I understand the challenges there. But as far as the Wells meetings, having been in a lot of them over the last 2+ years, as well as obviously before then, I really haven't noticed any difference in the effectiveness of counsel, and hopefully not in the effectiveness of the staff in communicating with counsel in those meetings. Again, and I think some of it may be generational. Like, I just have a personal view that there is no substitute sometimes for in-person for all the reasons everyone is thinking about and talking about, but I think it's a pretty effective substitute, and it does sometimes expedite things by not having to deal with, outside defense counsel, calendars and travel and whatnot. So I think it's a balance.
So in other words, whether it's in person or virtual, you've already made up your mind.
No. If that's what you heard, that isn't what I said.
No, can I ask one follow-up question?
Yeah.
No?
The only thing I would add to that is you're certainly not pushing at your own risk. If you have a strong interest, I would love to hear about it. I can't promise you anything, but it's not a risk to do that.
And then I guess just one more follow-up to that. I guess if you are getting what you think is unfair pushback from the team in doing something in person, if you have a really good reason to do it, I think it's fair and appropriate to tell the team you're not satisfied with that response and you want to elevate it. And, if need be, we can all have a discussion about it.
So if a staff attorney says, we'd like to take your client's testimony and we'd like to do it by WebEx, and our preference would be, we'd like the opportunity to do it in person, not only because of exhibits, but because, we actually would like you to see our client in person, what should our response be?
Well, I think you can probe and say, is there some reason, are you reluctant to come in? Is there a concern about health, safety? Is it convenience? Like, what is the obstacle that prevents us from coming in if we're willing to do it voluntarily?
Okay, great. So let's switch topics, talk about the settlement process. And I'm going to direct this one first to Randall. So there have been some changes. For example, let's say you wanted to settle a case on a non-fraud fraud claim or something like that, but you didn't want to lose the safe harbor. You used to be able to make contingent offers. Say, can we settle but get a waiver of that provision? Or you used to say, I can take it up the chain and I could meet with some higher ups, for example, right? You used to be able to do that more routinely. I don't know why I did that. But and now we hear, sometimes we don't really have to. It takes too long. It's just routine. So Randall, have you found any changes? And if so, do you think these are positive changes, negative changes?
Just to take the two issues sort of in reverse order. On the issue of, sort of excessive Wells meetings or not, the sort of message that Grabir sent in his speech, I honestly haven't particularly seen a change. I mean, in my experience, well, first of all, I didn't perceive it, and it's been a long time since I've been on your side of the table, I didn't perceive it as a problem in the first place. So to some degree, it wasn't entirely clear to me what the problem was that needed fixing. I've never thought of defense counsel as abusing our, requests to ask for meetings. But no, I haven't actually seen a change. I think, we try to be thoughtful and careful about when we think an escalation is appropriate. On the issue of contingent settlement offers, I think I don't quite know actually what the staff's on the enforcement side's position is now, and whether the staff will, for example, enter into an agreement to allow somebody to withdraw a settlement offer if you don't get the waiver? I think that's really the question, because obviously for any number of clients, it is a critical deal point, and you simply can't, proceed with the settlement if you're not going to get that waiver. So is allowing somebody to back out of a settlement if you can't get that, is that something the enforcement staff will allow?
Let's ask someone on the staff. So how about Monique?
I mean, I have to go back to Acting Chair Lee's statement that she made in February of 2021. I think it was pretty clear. She indicated in that statement that the Division of Enforcement would no longer recommend to the commission a settlement offer that was contingent on the commission granting waivers from certain disqualifications, WICSI, Rule 506 of Reg D. So I think that's fairly clear. In practice, I actually haven't run into any difficulty with this perceived, whether it's a real or a perceived change. I do think some things have slowed down maybe in the process, but I don't think it's actually impacted. I haven't seen it impact a potential respondent's willingness to settle. And maybe there's actually a little bit of a positive impact that I have seen potential respondents actually go to the divisions, go to Corp Fin earlier, sooner, start talking about that potential waiver, start engaging in that process.
So what you're seeing is that some companies are, before they settle with you, they're going to Corp Fin to see if they can get that waiver.
Not actually before. I think it's sort of a
Parallel
process. Yeah.
Okay. So in some ways it accelerates that process. And what about Wells meetings in general? Have you seen any change in terms of going up the chain?
I haven't seen any change from my perspective. Maybe the one change that we've put into practice in San Francisco that I think is beneficial is starting to think more about how a white paper can really benefit us and can keep the process flowing. So asking for that white paper at the appropriate time, and maybe it's not so pushed to the end. We're going to do a white paper, then we're going to do a Wells submission. So I don't think white papers are always useful, but they can be, and I think my staff are thinking more about when they can be. Just yesterday afternoon, I actually read a white paper, and it made a difference in how I was thinking about the potential settlement of the case. And it's something that we actively engaged in because we saw an issue.
So for the few people in the room who aren't aware of this, can you describe the difference between the white paper process and the Wells process and how they fit together?
I mean, I don't know that they necessarily fit together. I think a white paper, sometimes whether the staff asks for it or someone offers to submit one, it's a way to tee up a factual issue or a legal issue, and for someone to present their thoughts to the staff. The Wells submission is a much more formal process where the commission issues a Wells notice, then there's a Wells response, and sometimes, not always, there's Wells meetings. Sometimes there's Wells meetings just, maybe at the office director, the associate level, the unit chief level. Sometimes there's Wells meetings with the front office.
So rather than wait for a Wells notice or Wells meetings, you can submit a white paper that tees up all these issues.
I mean, I'm not saying submit a white paper and tee up the issues every time. I think we would like to engage on what you might want to present on and talk about. And we will actively actually ask for one in certain situations.
I mean, I think that's a really good thing that the staff is open to receiving them, at an earlier point in time rather than waiting till the Wells stage, by which point, as a practical matter, in most cases, the staff views are pretty well entrenched by the time they issue a Wells notice. So I think the fact that you're willing to at least have a discussion about the benefits of a white paper is a good thing.
All right, switching gears just a little bit, Michele. Admissions. We talked about this probably 6-7 years ago, and then we stopped talking about it. Now we're talking about it again. So they're back. And I've read that they're back in appropriate circumstances, that enforcement will require an admission, or where conduct is egregious. So can you perhaps just enlighten us a little bit more on what appropriate and egregious mean in this context?
Sure. So first, since in our prep session you were very focused on egregious, so I did look it up in the dictionary.
Oh.
And
what's a dictionary? Like in a book?
Flagrant.
Yeah.
Flagrant. And according to the Cambridge Dictionary, bad beyond a reasonable degree. So crystal clear guidance there, right?
Bad beyond a reasonable degree.
Yes.
Okay. Not just like reasonably bad.
Yes.
Okay.
So as far as appropriate, I would go back to Mary Jo White's speech, an announcement of admissions almost 9 years ago, or more than 9 years ago in 2013, where she said that there's a special need for public accountability and acceptance of responsibility. In those cases, admission should be required in settlements. And then she identified a variety of factors which still are relevant and guide and inform the staff's thinking as whether or not to recommend admissions. Cases where there's a large number of investors who have been harmed or the conduct was otherwise egregious. Cases where the conduct posed a significant risk to market or investors, where admissions would aid investors deciding whether to deal with a particular party in the future, and cases where reciting unambiguous facts would send an important message to the market about a particular case. And then in Gerbert's speech, one of his speeches last fall, he also identified that we'll consider admissions in cases involving obstruction of the commission's processes and where admissions will greatly amplify the deterrent effect of the action. And then this also would include situations involving recidivists, which I think is significant. And then I think it was in the Silicon Valley panel this morning, they talked about the JP Morgan settled case in the context of violation of the broker-dealer record-keeping requirements. And then in that case, the firm for a period of 2 years had allowed employees, and including senior management of the firm, to communicate using their personal devices and not retaining those records, which are required books and records to be maintained. That's a vital part of the commission's processes in the exam process and the enforcement process. So I think that squarely fits into one of the factors where to give an important message to, in this case, the registrant community, which I know struggles with dealing with, bring your own device and people using personal devices. But the reality is there's a big commission important need to make sure that those records are maintained as the rules require.
So the last time we went through admissions, I think it wound up that maybe 2% of matters, something like that, wound up requiring admissions. We heard this morning about the more aggressive enforcement posture these days. Do you see that it's still going to be like a real outlier to get admissions, or just going to become more routine?
Well, I don't know that it would be routine, but I think, you don't always like to hear it, but I think in the appropriate facts and circumstances, there certainly, I think, is an appetite by the commission to see these types of settlements. And I guess one other comment just on the drumbeat of the aggressive approach that enforcement and the commission is taking in a variety of things. I guess what struck me listening to all the panels so far today is there something about being aggressive when you're a regulator? Like, is there something pejorative or negative about it? Where I think it's the mission, we have 3 important parts of our mission, and again, my personal view is we should enforce those and fulfill them in an aggressive way to allow us to carry out the mission. And we have a lot of process at the commission and guardrails that I think it's striking the appropriate balance.
So Randall, is aggressiveness a good thing?
Well, look, I don't think the issue is aggressiveness. I think the issue is aggressiveness paired with vagueness in how you're actually being aggressive or what's going to guide your prosecutorial decisions. And I think the admissions thing is sort of a perfect example. I mean, all of the so-called guidance on the kinds of cases where admissions will be required is almost inherently vague. And, even a lot of the rhetoric from Mary Jo White years ago or from Gerbert more recently on the importance of admissions to, for the public trust and as a clarion call to other companies and so on is inherently vague, and it is essentially whatever the staff wants it to be. And so I think that's where you get that tension, is aggressiveness combined with this inherent vagueness.
So along those lines, I'm going to move over to penalties. And penalties, we're told that the commission is going to focus on egregiousness. That's what the commission's going to focus on. And that comparable cases, you can't just say, well, here are 5 cases just like the one that I've got, so the penalty should be this. It's like, well, maybe. Now we're told that might be one data point. And they'll also take into account recidivism, which is kind of an odd concept in a way when you're talking about a corporate entity, when shareholders change, management may change. So, Jina, are there standards, or are we starting to wander off into kind of subjectivity that Randall was talking about?
I think what's frustrating to clients and for a lot of folks is the great deal of discretion that the SEC has to impose penalties, to get admissions. All of these involve discretion by the staff, and I think that can be difficult to explain to a client. I think the idea that penalties are arbitrary and capricious, I don't believe that's the case. I think that the staff is willing to hear and wants to hear about other like cases, and we'll hear that. I think, though, that on some level, this need for higher penalties, I think it feeds into the public cynicism about what that really is. Do the most impactful cases extract? Do you need a huge penalty to really bring a party to account? You look at the J.P. Morgan books and records case. That is, an impactful, significant case, a 9-figure penalty for a books and records violation. I think that says something. I think you are also seeing significant penalties for other non-scienter-based violations, and I think that's something to keep an eye on. I think this idea of kind of the penalty analysis that traditionally happened, kind of balancing harm to shareholders and benefits to the corporation, I don't know that is necessarily something that the commission or the staff is really taking into account right now. So I think that it is a time where there is a good amount of discretion when it comes to penalties.
So, Michele, I'm sensing you'd like to respond to some of these.
So first, on the issuer penalty, and that really is where the benefit and penalty analysis comes into play, that is still an exercise and that the staff goes through, and it's part of the recommendation. Does it begin and end there? No. And as Commissioner Crenshaw mentioned in one of her speeches this year, she really focuses on the egregiousness of the conduct. And then on the point of what is the purpose of a penalty, right? It's to specific and general deterrence. So specific deterrence, obviously, so the individual actor does not engage in that violative behavior in the future, and general deterrence for the public at large. And so I do think some of this is in the eye of the beholder, right? Because a lot of times when we announce penalties, there will be a response in the defense, not necessarily the defense bar, but in the media, in other stakeholders, that it's a slap on the wrist and it's just a cost of doing business and the SEC has no teeth. Then if you impose a more significant penalty, then it's arbitrary, it's capricious, it's disproportionate, it's unfair. So I do think it's always striking that balance of taking into consideration the facts and circumstances. And again, as far as general deterrence, where you see similar misconduct repeatedly engaged by different actors with people relying on, quote, the comps, I think it's a fair question to say, perhaps we're not achieving the general deterrence that was meant by those penalties if that conduct continues. And again, on the discretion point, and this is to Randall's point too, or the vagueness, the securities laws in general and the enforcement process is very much a lot of discretion, right? Somebody is developing evidence, applying the law, mindful of the public policy, mindful of all the due process and equitable and fairness considerations. But I think what the protections there is, it's not any one attorney at the SEC is determining, like, I am bringing these charges against you. There is a lot of process, and even though the process internally sometimes can create frustration, I think it's vital for the integrity of the process, and it does ensure fairness and a lot of de novo review along the way to make sure that when we are applying these principles, we're doing it in a fair, measured, and consistent way. And can someone look at any one case or decision and think it's not fair? Absolutely. But I do think that is the process, and at least that has been my perspective.
Monique, did you want to add anything to that?
No, I think Michele did an excellent job of answering the question. I mean, I do. Maybe I do want to add something, and now that I'm adding this, I think I may not have expressed the fact that the views that I'm expressing here today are my own, and not necessarily those of the commissioner or any of the staff. But I think probably comps are always going to be there. So I don't, even though maybe there's a perception that there's a significant deviation from the comps, we're always going to be talking about comps. We're going to be talking about comps internally. We're going to be talking about comps with you if you bring them to our attention. But for the specific and general deterrence, I do agree that perhaps a rise in the penalty levels is necessary in certain circumstances.
Okay, so one thing that I've read, and Michele, I'm going to direct this to you, is that the commission is looking for high-impact cases. High-impact cases. So I'm thinking of a low-impact case. I mean, you're sort of ignoring those. Maybe that's probably not true. But then I read about one that you're litigating, which caught my eye. And it's against Big Money Mike 6. And so I was curious about Big Money Mike 1, 2, 3, 4, and 5. And Big Money Mike 6, you should look up. I mean, it's pretty interesting. You know, he says, I guess this is on Twitter somewhere, that we make money 24/7, follow me to the land of milk and honey. And it almost rhymes. So it seems like an interesting case. I don't know if it's a high-impact case, but what can you tell us about that case?
Well, I guess first I would say, as you often hear, like we do cover the waterfront, right? So it's important to bring significant, high-impact, big, complicated cases, but to make sure that our presence is out there in all the other areas and the cases in litigation. So I cannot comment beyond what obviously is in the charging document. But there, Big Money Mike, Mike Beck, has 3 million followers on Twitter, which is not insignificant, and he was engaged in a scalping scheme.
Hey, what is
Scalping. So he was promoting stocks, and prior to the promotional campaigns, had been purchasing stock in either his own account or nominee accounts and not disclosing that, and then reaping profits after the price would rise in response to the promotion. And part of his scheme was in targeting some of the investors. I think it was called the Team Billionaire, his email list to identify the stocks that he was favoring, and that was, creating some of the increased volume. So that is a scheme. There were 3 million people who were following his scheme. And so I think also with just the social media aspect of enticing a lot of unsuspecting investors, that is a significant
And
case.
he's fighting the charges.
It's in litigation.
Interesting.
I made money off it. I don't know what to do.
Big Money Randall.
Team Billionaire.
Randall 6. Excellent. Okay, so now we're going to switch over to a topic that was touched on in an earlier panel, which is the whistleblower topic in the Hansen case. And it's Rule 21F17A. How about that? And in that matter, the SEC said that you can't remove a whistleblower's access to company data, even when the whistleblower said, I'm going to give this data to the company's competitors. And Hardy said, and he was up here, you have to be very careful in this area. Okay, got to be very careful in this area. I now call you, I'm the general counsel, I call you, Jina, and I say, okay, I know I should be careful, but this whistleblower is going to divulge corporate secrets. Do you say, oh, let him do that, that's fine, you can't touch this guy? Or do you say, no, cut him off, and if the SEC comes after us, it's still the right thing to do? What concrete advice would you give to the general counsel in that situation?
The concrete advice I would give is first to praise the general counsel for calling me.
There we go.
And say it is really good. I think one thing, if you read through the order, and that order is not long, I think what comes through to me is this sense of reaction in the moment, and I think that happens with a lot of whistleblower complaints. I think that a lot of times there's a lot of emotion surrounding whistleblower complaints, so the idea that principals at a organization, and this was a non-public company, it struck me as kind of a smaller tech company, and what's also kind of interesting about it is there's, the charges are against the one individual, the chief information officer. There were no charges brought against the company or the CEO. But in any event, the idea that you call somebody, either you call compliance, you call your legal department, you call outside counsel to get a temperature check, to kind of lower the temperature on when it comes to these types of claims. I don't think it's an either-or situation, like, okay, he gets the documents, you can't cut him off. I think what you want to do is document the reasons, the business reasons for why you're taking the actions you're taking. And I think in the process of documenting, I think you get into a good position to assess what are the next right steps.
So it sounds like just take your time, be more deliberate. Don't just react and say whistleblower, a problem.
One, but I think documenting your process, and I think that there are several compliance folks that I see in the audience, several people who are in-house, and I think that documenting business reasons is a theme through a lot of SEC enforcement.
So it doesn't come across as vindictive.
Exactly. I think that the idea that you have an employee who wants to release confidential, proprietary, or information that contains PII, I don't know that anybody in an organization should countenance that.
And Michele, if that was presented to you, you'd say, Jina, nice job, fine, we're not concerned.
I think it's not looking at the facts and the context that existed in this case, which is the whistleblower complained to others in the company in the year prior. Then he complains directly to Mr. Hansen. Then Mr. Hansen, and he complained both before, the company didn't do anything. He files his tip with the SEC, and then he complains again to Mr. Hansen. Then Mr. Hansen, then as you heard this morning, then he immediately texts the CEO and they cut off the access to the whistleblower, but not in a direct way saying, we believe you're going to compromise our confidential information. They limit it to read-only access, so they're hoping he doesn't notice that the access has been cut off. So I do think in those circumstances where not only did Mr. Hansen know that he had concerns about the inflated customer numbers, in the order it also says that Mr. Hansen appreciated that this could be a violation of the securities laws, and then they cut off his access to the documents. I don't think it's a stretch to say that action could impede the reporting and provision of information by a whistleblower to the commission.
And I think the real question, though, is do we draw any broader lessons from it? I mean, what you've emphasized is the very fact-specific nature of that case. But the real issue, it's a real issue, is are there broader lessons that we should be drawing on the defense side? What about an employee who starts forwarding confidential information to his or her personal email address? Is that alone? What do you do about that if you're a firm?
Well, I don't know that in the whistleblower.
A whistleblower starts forwarding information to his or her personal email address.
Again, I guess it would depend, but I think the takeaway from this case does not mean an employer cannot limit the access and dissemination of trade secret and proprietary information outside the organization. But that really isn't exactly what happened here.
Yeah, I think, another claim in the order is, and I would put this in the bucket of try to learn from others' mistakes, but the idea that, and I've talked to our privacy counsel, who I end up talking to a lot, but the idea that, individuals at that company might have taken personal passwords and accessed, individuals' Google accounts, Facebook accounts, Glassdoor, that just sounds like not a place you would want to be.
All right, last question for the group. We're gonna go down, everyone's gonna get a chance at this one. So what is the one thing that you've put off doing during the pandemic that you're now planning to do? I'm going to start with you, Monique.
Can I say something that I've actually started to do already?
Starting, that qualifies.
I actually started riding my bike back to the office, which I didn't do obviously we weren't at the office, but we're going back voluntarily. And to go back voluntarily, I decided, yes, I'm going to ride my bike again.
So maybe this is TMI, but are there showers at the?
There are. Although it's pretty lonely there still.
Well, that's the recruiting tool we've been looking for.
They're not free though. You actually have to pay the building for them. So.
Oh, not every
The SEC is not covering my
like a paid
shower.
where you put a quarter and the water comes down. Not like that. Okay. The SEC fronts that cost. Well,
No, they don't.
Oh, they don't. Oh, they don't. Okay. All right. Well, it still sounds worth it to me, especially if there's going to be in-person testimony. So Randall, how about you?
I'm going to have a ceremony in my house, a ceremony, and I'm going to burn the 3 pairs of shorts and 2 pairs of sweatpants that I've been wearing literally every single day for the last 2 years.
Yeah, we've been meaning to talk to you about that.
But maybe he should save those for in-person testimony.
Yeah, that would be good. It's good to know that there were at least shorts and sweatpants. Okay, so Michele, how about you?
I was going to force my husband to clean out the garage, and I was going to help, and yeah, we still haven't done it.
That's going to be on the list a long time, pandemic or now. And Jina, how about you?
Well, I was hoping to engage in international travel, but it sounds like that's still a ways off. I received an email this morning from our firm that has offices in Asia that people are under lockdown there, so it still might be a while.
Yeah. All right, and what I'm going to do is I'm going to show up at events like this. Okay, thank you all.
Thank you, big money, Jordan. Appreciate that. All right, so we're now at the lunch break. It's about an hour, and during the lunch break, we're going to have a keynote by SEC Enforcement Director Gurbir Grewal. He's here. For the many people who have asked me, he's actually here, which is great. The plan is we'll vacate this room until about 1:05. They'll come in, they'll put all the food in, come back in around 1:05. At 1:10, we're going to begin the keynote. We have an introduction from Joe Grunfest, who's zooming in, and we'll start right after that with Gurbir's keynote. Thank you.